Good afternoon or good morning, depending on where you are. Welcome to our webinar on WRAP programs. This is Steve Wilkes on behalf of the Wagner Law Group. I'm here in our San Francisco office. Welcome to the webinar. Today we're going to focus on the current status of WRAP programs, what the SEC has been saying, and talk a little bit about some of the recent enforcement activity. I think that the SEC has had a focus on WRAP programs for quite a while, as have other regulatory agencies, and there's a lot of interest in them, so it'll be good to refresh ourselves a little bit on the current environment for WRAP programs. So for the agenda, I'll try to set the stage and just give you a little bit of background on the WRAP programs in the industry. There's some general things. So I know that most of you in the audience have an understanding of WRAP programs. We'll kind of highlight and call out the SEC focus, and then really as a precursor to talking about the SEC enforcement activity, we'll talk a little bit about some of the structural components of WRAP programs. And I think one of the takeaways there is you'll see how complex they are. They're varied. They take many forms and shapes and sizes. A lot of ways to put them together. They trigger potentially a lot of different issues. So we'll talk about the structuring a little bit, and then we'll finish up with some of the SEC activity over the last couple of years. WRAP fee programs or WRAP programs have been around for quite a while. When they first came out, they were kind of viewed as a product to be offered to the elite, very wealthy investors. But they've evolved and morphed and developed over the years to also become available to, much more at the retail level, if you'll allow me that term. I think technology lets that happen, and just the ability of scaling and firms that are willing to work with smaller account balances. And there are so many different, combinations and ways to put these together. So I think that they're scaled across the investor spectrum, from significant high net worth individuals to smaller account sizes. The common denominator, of course, is that, WRAP fees are named, WRAP fees are programs that have a wrap. In other words, for a single fee which wraps around the entire program, you get a variety of advisory services, maybe reporting, and the brokerage execution itself, the stock trades or the investments. They're all wrapped together. Typical fee structure is, percentage of assets under management. There's also a lot of different terminology and types of accounts. I'm sure many of you are familiar and think about WRAP programs in terms of being, an SMA, UMA, third-party asset management, or maybe one where, the rep or the advisor is either sending you to another party or managing it himself or herself. We have asset allocation programs. Some WRAP programs are limited to mutual funds, target dates. Sometimes they're called mini accounts. Some WRAP programs distinguish themselves by focusing either on proprietary or non-proprietary product or service providers, overlay programs, and so on and so forth. But again, the key is that you bundle together a host of services around a single fee. So these things can be very complex. A lot of special rules arise from the utilization of a WRAP program. There's some special rules about, for example, Form ADV rules, confirmations, the potential to inadvertently be a registered investment company where you get your safe harbor under Rule 3A4, some ERISA considerations that are special with regard to WRAP programs. I think when you think about the regulation and compliance task at hand here, you almost have to look at these, you have to self-assess, and if you're sponsoring or managing a program or part of a program, or simply advising or selling a client into one, you need to be thinking about what are the services, who provides those services, what do each of the different parties do that are part of this bundled program, what are the different services we're getting, are any of them fiduciary or non-fiduciary, What do we pay for each service? You know, I mean, is there a way to break it down, or, you know, or at least understand what the cost allocation looks like? Are there any extra fees that aren't necessarily accounted for in the RAP fee? What's the standard of care? How do you report performance? Who chooses the funds or the managers? So on and so forth. So as you can appreciate, you know, a lot goes on with regard to either sponsoring or managing a program or investing in one. Now, it should come as no surprise to you that RAP programs or RAP fees very frequently come up either as the subject of a specific targeted enforcement activity for a given year or an area of alert or concern. You know, the SEC, you know, FINRA, state regulators, it is not uncommon to hear them that they're taking a look at RAP programs, they have an interest in RAP programs, there's going to be a special sweep of RAP programs, so on and so forth. And the most recent activity was an investor bulletin back in December. We had a lot of client calls on it, as a matter of fact. And, you know, it called out some of the issues that might arise in a RAP program. So I think it's a really good roadmap or a guide for, excuse me, for people to think about. You know, that came out in December 7th. It was the SEC's Office of Investor Education and Advocacy. They put out an investor bulletin, one of the many quality bulletins they put out. And the bulletin, you know, provides information about programs, and it's kind of geared to the investor, but I think it provides a good roadmap of areas where the SEC is concerned. They note, you know, when they define a RAP fee program, they start out by explaining it as an investment account where you, you know, assessed a single, you know, fee, or a bundled fee, if you will, that covers, you know, advice and brokerage, administrative costs, excuse me, and any other fees and expenses. And, you know, there's lots of different names that these things go under, and the SEC acknowledges that a rose by any other name would be no sweeter. They acknowledge, you know, there's asset allocation programs, mini accounts, UMAs, SMAs, what have you. They define, again, the common denominator as that one fee that is the RAP or that ties it together. The SEC notes that, you know, you typically have a sponsor, there may be, and that there may be more than one sponsor in certain programs, which raises the issue as to how they share responsibility or allocate responsibility for things like disclosure and who has the primary responsibility. One of the things they point out early on in their advisory bulletin is the potential for trading activity, you know, for trading away, and how costs can run away from you because, you know, the RAP fee is, you know, based on your account value. And, you know, depending on the amount of trading activity, you know, the fee, you know, it might cover the, you know, it covers the cost for all or most of the trades. But I think they raised the question, you know, and suggest that if you don't have a lot of trading activity, you know, you might end up paying more for a RAP fee program than you would for doing individual trades. You know, it's the reverse churning thing. So I think that's an area that's called out frequently and is of current interest both at the SEC and the Department of Labor. They go on to talk a little bit about some of the disclosure rules. We'll talk about them a little later. You know, the special form ADV rules for a RAP fee brochure and the kind of information that goes into it. And I think they talk about looking for, you know, making sure you really understand, you know, what kind of investment advice is being given, who it comes from. Is it pure investment advice, or is it just something less? Is it financial planning? What does it cover? You know, all the aspects of brokerage costs, you know, whether it's for buying or selling securities, and whether there's any markups or markdowns involved. They want you to be alert to administrative expenses, other fees and expenses, you know, third-party costs and trading away. You know, so when a third-party provider, you know, third-party service providers might provide services to an advisor who sponsors the RAP program, and the RAP fee typically covers this, but sometimes a provider offers these services in a manner that triggers an additional cost. So, you know, this is, you know, trading away, and that could trigger additional brokerage expenses, and that's something the SEC is very alert to and has seen some abuse of, if you will, in the marketplace. So trading away is has been highlighted by them. And again, I think these things are really roadmaps for your compliance department and your program offerings, to kind of self-assess how you're doing. So again, key question: what are the services? Does the RAP fee program make sense for a client or not as compared to another type of account? Is the account actively traded, or is it a buy and a hold? What are all the fees and expenses? Are there any other fees and expenses that are not part of the RAP fee? How do you get out of a RAP program if you're in one? So on and so forth. So we'll talk about them later, but this bulletin ends with the SEC noting several of the recent enforcement actions they brought against a few firms, which at the end of the day came up with something to do with the RAP program, some sort of compliance failure or failure to clearly disclose. And again, the reverse churning, the features, trading away, adequate disclosure, the reasonableness of fees, these are all aspects that the SEC is looking at. I can tell you from the sidelines, the DOL, when they're involved, they're looking at it also through their fiduciary lens. And, investors, knowing investors are looking at these kind of things as well in terms of making their decisions. So let's talk a little bit about RAP fees, and many of you already know a lot of this in the audience. I think it's good to kind of just do a quick run through on some of the key components, because it's provocative in terms of making you realize all the kind of problems that might arise, the issues you might have, and these are the things that ultimately end up potentially, as an area of concern with the SEC. So, kind of starting off, who's in these programs? It's a bundle of people. Who's in the program? There's a lot of different people. As I said before, you could have a sponsor who basically runs the show, puts it together. Clearly, a very strong fiduciary responsibility under the Advisors Act in terms of meeting standards of care and making disclosures and what have you. Sometimes, if you have more than one sponsor, depending on how that, how the Advisors Act defines that, whether or not you fall in that definition, the sponsors will allocate among themselves as to who's responsible for what and who's going to make the disclosure of the, the RAP brochure and what have you. So, typically we see broker-dealer firms, sponsoring RAP fee programs, and there's a lot of specialized programs that can come out of that. The reps are either managing money on behalf of the firm, or it could be third-party managers, could be asset allocations. There's a lot going on there. I also want to remind everyone that when a brokerage firm is involved in a sponsor, more often than not, in pretty much all instances, this is a situation where you also need to have, proper registration status under the Advisors Act. And that's something to keep in mind. Occasionally that slips. Newer firms or younger, less experienced firms, that tends to slip by them a little bit sometimes. And it's interesting, I just want to point out kind of the converse here. So you have a situation where, the broker-dealer may need to make sure that, the broker-dealer is registered as the manager. But the converse is true. There's also a little bit of discussion around the question as to whether an advisor that's sponsoring a program needs to be registered as a broker-dealer. So, typically, advisors advise and a broker executes. And, advisors, have, asset-based commission, and, they might, and brokers typically have transaction-based commission, if you will. So, in a RAP program, sometimes it can be very subtle, but it might be a broker-dealer registration issue. So, this would come up where some of the fees that are being received by the advisor might look like transaction fees or commissions for transactions. So depending on the nature and characteristics of the fees coming in, an advisor that is a standalone advisor that's not dual registered should really understand and look at the flow of monies coming in and the flow of fees that are coming in to make sure that it's not inadvertently triggering a registration requirement as a broker-dealer. So I wanted to point that out to you. So that's it. So you have a sponsor. And, you know, the managers are, you know, they manage the money, you know, different overlay managers, sleeve managers, they're the ones who might be, you know, they might have one or more special classes or categories. Programs vary. Sometimes the sponsor selects managers. Sometimes it's available for the investor to make that choice. Sometimes these managers are affiliated with the sponsor. Sometimes they're not. And these are things that all have different ramifications and that need to be thought through. You always, of course, have an individual, key with the client, your IAR, or registered rep, who's kind of facing the client. And this is somehow sitting on a platform somewhere that has all the technology and infrastructure and reporting and electronic capability to, for the program to run. So those are some of the, and then if you're investors, of course, and remembering, especially nowadays, to keep in mind the distinctions, the very important distinctions between qualified retirement accounts, IRAs and ERISA-governed plans kind of take a whole, needs a different analysis, if you will, or a different sort of review and structuring maybe than a taxable investor would have. So some of the other issues that come up in this scenario, when you're putting a program together, you have disclosure issues that can be fairly significant. I mentioned before that there's a requirement for disclosure of the ADV Part 2A. So typically, the SEC acknowledges that, RAP fees, the DOL acknowledges that RAP fees are okay. And I think that, we've morphed to the point now where you have, it used to be the old Schedule H, now it's the appendix, for RAP fee programs. And ADV Part 2A, Appendix 1, is a special requirement for disclosures and has its own construct and its own instructions. For purposes of these ADV requirements, a RAP fee program is defined to be any program, where clients charge a specified fee that's not based, on transactions per se. It's kind of that flat level fee, that all in. And the SEC has also clarified over the years that certain accounts are not considered RAP-free programs for these purposes, like mutual fund asset allocation programs. So you have to understand that most RAP-free programs, but not all, are necessarily going to have to be engaged with Form ADV disclosure. One of the other special things that comes up in this area is confirmations. Under the 34 Act, 10b-10 rules. And, there's been a whole body of law here and a whole best practices in terms of confirms. So typically, broker-dealers that are doing transactions and RAP fee programs, or, you can send confirmations, typically only to the advisor instead of the client, if the client is given authorization and the client nonetheless gets periodic account statements. And there's some information and requirements around what these account statements might need to include. And there's also some other, relief for broker-dealers, with periodic statements versus, trade-by-trade confirmations. The whole point being that, the brokers, sponsoring RAP fee programs, may or may not be able to rely on certain exceptions, around confirmations, when they're receiving separate compensations. The whole area of confirmations needs to be understood and studied carefully when you're involved with a RAP fee program. And one of the other big things that comes up is just, generally speaking, is marketing. And you need to be very careful, just the standard litany of issues, but you need to be very sensitive to the quality of your disclosures in your marketing, the documentation, how your performance reporting, things like this. The considerations that go into the content of your marketing materials needs to be very carefully assessed in any RAP fee situation. So, a lot of times you're dealing directly with clients. Sometimes you're dealing with a wholesaler. you know, if on the Advisors Act side, you have, you know, fiduciary standards, anti-fraud rules, the FINRA rules, you know, maybe are written a little bit differently. So I think you need to thread that needle, you know, very carefully. And then, you know, the same thing with performance, as I said before, performance, presentation. Think about your GIPS standards and what have you. And in terms of, you know, mini accounts, we get into the whole discussion. You know, you have, so you're sponsoring a program, you might have hundreds, thousands of small accounts. You know, at what point are you potentially, you know, have a pooled investment so that you really have it's a mutual fund and it needs to be registered because of the similarity of treatment of clients. So it's always a potential argument that what you're really doing is managing all these individual accounts, you know, under one umbrella, and that, you know, it's an investment company, you need to register. And there have been sanctions. I mean, the SEC has issued no action letters over the years and has taken action on it. But ultimately, as you all know, you have to, you know, think about Rule 3A for relief under the Investment Company Act, and I guess for relief for registration with the Securities Act as well. And you know, you get a safe harbor, you get a pass if you can show that every account is somehow subject to some sort of individualized criteria, managed on the basis of individualized criteria. You know, at least once a year, you check with the client to see if any changes are required or objectives have been shifted. That you're basing, you know, these investments on individual information you've gotten from the client. That you consult, you know, that the clients get a quarterly statement, and so on. You know, there's a list of criteria under 3A4. So most people are able to get through that and work with that, but it can be a little bit problematic, and it's something that you need to keep track of. Another issue that comes up, generally speaking, is just, and I mentioned trading away before, but just, you know, just the whole trading aspect of you know, trading in a wrap program can be pretty complicated. I mean, you know, when you have a bundled program, I mean, you know, in theory, it kind of takes away the incentive for churning. But, you know, you have to think about reverse churning in terms of suitability and some other things. You have to think about whether the broker-dealer, you know, is getting best execution and how they're choosing the broker. Is it an affiliated broker or not? These are the kind of things that you need to really watch carefully. And, you know, best execution can really be problematic in some of these programs. You need to be very careful with that, and just, you know, the general sequencing of trades. And, you know, if you're acting as a principal and, you know, if you're making investment recommendations, you need to be very careful about how some of the rules play out under the Advisors Act. So there's a lot going on in the complexity of the trading. And suitability is the same thing. It's fees, reasonableness of the compensation. Is it appropriate, you know, churning, reverse? Are they better off if it's a buy and hold? Do they really belong in here? So these are a lot of the things these are a lot of the issues that tend to come up in a wrap program. I wanted to call them out to you because when you implement and operate the program, you get into the legal status of the parties, you know, various, you know, trading rules, pooled investment rules, suitability, and so on. And that's kind of when you run through that checklist, you can also imagine that the SEC, you know, they're looking at the same factors when they're evaluating your program, and these are the things you really want to be aware of. Let me talk about ERISA for a little bit. You know, a lot of times, you know, I have, and our firm has done a lot of ERISA webinars for you. This webinar today is really focused more on wrap programs in the sense of being a program under the securities law. But let me just point out that for ERISA purposes, wrap programs, there's been a lot of talking about wrap programs in the last year or two, because wrap is a way of maybe leveling and solving some of the conflict problems under ERISA. So, you know, I mean, clearly the DOL has said that, you know, ERISA, you know, in their advisory opinions has said that, you know, a single fee, a wrap fee is okay, but nonetheless still have a fiduciary duty, you know, in terms of how you manage all those assets. You have to make sure that it works properly. and you need to be mindful of, ERISA plan versus, a qualified retirement plan such as an IRA or, a solo KEO or something, because, the analysis and kind of filtering through the ERISA analysis might be a little bit different. But the thing I also want to remind people here about ERISA is so a lot of people, if you're advising, the BIC applies, and maybe you're going to use RAP as a way to level out commissions or something, that's part of your BIC strategy. It's a little bit tenuous these days because we're under the impartial conduct standards. A lot of the final BIC things haven't been worked through, and we'll see how they play out over the next 6, 7, 8 months. But RAP sometimes is, level. That is a way to level and kind of, get some sort of objective treatment of compensation under the BIC. Let me remind everyone, if you're managing assets on a discretionary basis in a RAP program, forget about the BIC. It doesn't apply to discretionary programs. It only applies to advisory. So a lot of people have gone to a RAP or a leveling approach with their programs to kind of even out, take out the ERISA prohibited transaction issues. And in our experience, what we've seen is that, you need to remember that even if you have a level fee, you charge 150 bips no matter what. Here's what you charge, here's what the client gets. And the client pays 150 bips no matter what. But as the program sponsor, if you have the ability to pick and choose the players, if you swap out one sleeve manager for another, replace a more expensive manager or a more expensive party in the program with another less expensive, and therefore the net remaining compensation due as the sponsor increases, even though the client is paying the same, you've just done something where you're in troubled waters from an ERISA perspective. So you need to be very careful when using the RAP fee as a solution. And you need to understand how it impacts you even though the total of the fee is constant, as the parts change and the net changes among the parties, you need to be very sensitive and careful about that. So let me talk a little bit about, what's happening on the enforcement side, what's going on. As you can guess just from our conversation, the SEC is interested in, suitability, conflicts, disclosure, adequate disclosure, trading away, proprietary versus non-proprietary, best execution. These are the things that just tend to, you're in a complex RAP program, these are the kind of areas where one can stumble, where there can be a glitch. So let's talk about some of the areas. I think, as I mentioned before, the alert, the bulletin back in December pointed out a couple of recent enforcement examples. They called out, the SEC noted, Raymond James and Robert Baird and Riverfront and SN and Company as having been examples of companies where, under the guise of the RAP account, there was a problem. So I think that shows you that they are looking at these, and when they're conducting audits and looking at firms, they are interested in seeing how the RAP program works out for people. What they found with regard to Baird and Raymond James, the SEC investigations found that those firms had failed to establish policies and procedures necessary, to determine the level of commissions that their clients are being charged when sub-advisors are trading away with a broker-dealer outside of the RAP program. So the SEC said, without this information, the SEC said the FAs, on behalf of the clients, were unable to provide the magnitude of these costs to the clients, and they didn't really consider these commissions when determining whether they were suitable. So clients didn't really know exactly what they were paying or how much they were paying beyond the RAP fee, and they settled those without admitting or denying, and it's just evidence of the fact that the SEC is looking at it. So this whole trading away thing, it wasn't just James and, I think Riverfront Investment Group and Raymond James and Baird and SN and Company, they were all sanctioned over the last couple of years. These are all really, really good firms where something just went awry and the SEC didn't like it, so they stepped in and exercised their enforcement responsibility. So I think, going back, I think to around 20, I think around 2010 or 11, there was a sweep, maybe it was 2014. There was a sweep on these wrap accounts, and it's been stated in exam priorities a couple of times that trading away and wrap fee programs and best execution and wrap programs are targeted. These are priorities, so people need to be aware of it. So again, on these wrap accounts, the SEC is the client being overcharged? What does the client know? What does the disclosure look like? Is anyone monitoring these sub-advisors trading away? Who's in charge? What is the sponsor doing? Is it really best execution? So again, the concern here is that the sub-advisors trade away through a broker-dealer, where you end up with a fee on top of the wrap fee. So in the Riverfront, and by the way, if anyone wants the sites to the SEC investment releases on these, just shoot me an email or whatever else. I'll be glad to send you all these materials. On Riverfront, the SEC said they claimed or asserted that the advisor had made misleading disclosures regarding the costs. And that the firm changed its practices, over time, but the disclosures, there was a gap between what was happening and the disclosures. So clearly, you need to really keep track of these changes, and you need to make sure that they get put into your ADV as part of your updates or other disclosure documents that you're giving to clients, and you need to do it in a timely manner, and that your trade execution policies and practices mirror what you actually are doing out there in the world and reporting to your clients. On Raymond James, they said that same thing. They didn't like the level of compliance policies and procedures, and that there wasn't good information about the sub-advisors in terms of trading away and how much, and was it properly disclosed, and was it material or not, and the clients didn't really understand. They weren't really told what they were paying for trades. I think some of the statements only showed net prices. So again, someone needs to know what these sub-advisors are doing on trading away. How is it being disclosed and handled? Is that the best way to go? And again, as always, they need to be very upfront and direct with your clients, very good disclosures. So some of the things that could be done, in one of these cases, the advisor set up a website kind of showing some information about the percentage of, the number of times that sub-advisors trade away and the average costs, and this was something that helped mitigate their fine. In the eyes of the SEC, they were trying to get information out there to the clients. I think on SN, on Stifel, let's see, that was a case where they said, the advisor didn't have the right compliance policies, or maybe they didn't have any compliance policies on this particular issue in terms of tracking, sub-advisors, who was trading away, how often, how much did it cost. There was some disclosure that used the magic word, sub-advisors may do something, clients may incur additional costs, and, that just wasn't sufficient for these purposes in the context of what had happened. So, generally, the SEC felt that the language wasn't strong enough, it wasn't clear, and that the advisor needed to not only disclose that it might happen, but to take the extra step of either disclosing that it is happening, and if it did happen, to be very clear about the costs involved. So one of the things that Stifel did, which the SEC appreciated as part of their resolution, was that they began a much more rigorous process of getting information from sub-advisors about how these sub-advisors, trade and what kind of fees are triggered, what the sub-advisor trading and execution policies were. So again, I think the real thing here is that, this stuff is okay. This trading away can be permissible. It's not always in the best interest of the client or the most efficient, but it can be okay. But that implies that you've got good documentation, you understand the costs, you made good disclosures, and that it really works well, that it really is the most efficient way to go. Some of the other activities over the last couple of years, back in a couple of years ago, AIG, had a consent order in terms of not really keeping proper track of some trading costs, and they had policies and procedures that weren't fully implemented, and that's really so telling, because all these firms that are mentioned that the SEC cited here, I mean, these are really good firms. I'm sure we all know lots of people at these firms, and they have compliance-centric cultures and really do a great job in trying to reach out and work with their clients and their investors. But it's just such a large, when you have thousands and thousands and thousands of trades and accounts, as you all know, it's really hard to track everything. So the devil's in the details. You know, you have a policy. The worst thing from not having a policy is to have one, but not to implement it. And that's really kind of what happened with AIG. And the same thing happened. Barclays got in a mess, a little bit of a situation, I think, this past year in 2017. They were some services weren't delivered, but their clients were charged, and you know, under the wrap. So that's what happened there. And there was a big case a number of years ago with JP Morgan involving their, which I'm sure you're all familiar with. It goes back about 3 or 4 years at this point. At the end of the day, they just didn't really make the right disclosures about about proprietary products in this asset allocation program they had, and the SEC took, you know, conducted a very extensive review and identified a lot of conflicts of interest and failures to disclose properly, you know, within these wrap programs, and that took a lot of sorting out. That involved both the bank and JP Morgan Securities LLC. So we're living in a world where firms are competing for assets, investors are looking for new products. Wrap fees have a real allure. They have a place. Wrap programs can consolidate and bring together a lot of great services in an efficient manner, which works for everyone. We live in a regulated world where there's a lot of rules to follow and a lot of things to keep track of. I think one of the things that we've seen so much of at our firm over the last couple of years, again and again, are just finding that compliance and legal teams and, you know, management teams are totally aware of the right way to do stuff. They just didn't have it papered up properly. They didn't have it papered properly. They didn't have a robust policy and procedure that really spelled out to the compliance staffs and the supervising staffs and said, here's what you need to do, here's how we're going to document it. So, you know, in spirit, they were in compliance. They wanted to comply with all these requirements, didn't want to breach anything, but the lack of formalized policies and procedures didn't really get them where they needed to be. And I think that's one of the big takeaways from the last couple of years on the DOL side. It's morphing over to the SEC side as well, which is that you just need good policies and procedures and good documentation to evidence that you know what the rules are, you have a practice for following the rules, and that you are, in fact, implementing the rules and supervising people for compliance with the rules. So I think if there's any takeaway on this sub, it's to really look at your documentation and your compliance manuals and WSPs with regard to all your wrap programs, and just think about how they address trading away and confirmation statements and suitability and reasonableness of fees and all those different things. Because when you bundle them together, those are all the pieces of the pie that are required for compliance with a good, by a good wrap program. So that kind of takes us through. I just wanted to highlight some of the things that are happening. You can see on the SEC side what they've been looking at. Wrap programs continue to grow. The numbers are pretty impressive from the industry consultants in terms of the number of dollars that are in wrap programs. We are glad to be helpful. If anyone has any questions about the wrap programs or what's happening currently at their firm, just give me a call or shoot me an email, and we would be glad to respond and be helpful to you. Thank you very much for joining us today, and we look forward to seeing you at our next Investment Management Law Group webinar. Thank you.